On January 29, 2025, the U.S. Copyright Office made a significant announcement regarding the copyrightability of works produced with generative artificial intelligence (AI). This announcement came in the form of Part 2 of its report titled Copyright and Artificial Intelligence, which builds on a previous report released in July 2024. The development follows extensive public engagement, including over 10,000 comments from stakeholders illustrating the growing intersection of copyright law and AI technology. Key findings of the report. The central conclusion of the report is that outputs generated by AI may be eligible for copyright protection when a human author has made significant contributions to the work. This can encompass scenarios where human creativity is evident in the resulting material, such as through creative arrangements or substantial modifications of the AI-generated content. However, merely providing prompts to an AI system does not constitute sufficient human authorship for copyright purposes. Central principles. 1. Human creativity is essential. The Copyright Office reaffirmed that human creativity remains a cornerstone of copyright law. While AI can assist in the creative process, it cannot independently claim copyright for its outputs. 2. Illustrative scenarios for copyright eligibility. Integration of human-authored content. If human-created material is incorporated into an AI output, it can be copyrightable. Significant modification or arrangement. When a human significantly alters or arranges AI-generated content, copyright protection is possible. Expressive and creative human contribution. A human's contribution must be sufficiently expressive and creative to qualify for copyright. 3. No need for legislative changes. The report concludes that existing copyright laws are adequate to address the challenges posed by AI-generated content. There are no immediate recommendations for new legislation. Although the Copyright Office will continue to monitor technological advancements and legal interpretations. For future considerations, a forthcoming Part 3 of the report will delve into the implications of training AI models on copyrighted works, focusing on licensing and liability issues, critical matters for AI developers who have used large datasets for training purposes. Community reaction. The report has been met with positive feedback from the creative community, particularly among AI creators who see it as a recognition of their rights to copyright their AI-assisted works. Notably, artist Chris Kashtanova, who faced copyright challenges regarding her AI-generated graphic novel Zarya of the Dawn, expressed her enthusiasm for the ruling, viewing it as a significant advancement for AI artists. The Copyright Office's findings have been hailed as a victory for many in the AI filmmaking and artistic communities. Creators like Nem Perez, involved in AI-generated projects, highlighted the ruling as a confirmation of their advocacy for copyright protections in AI artistry. Implications for the future of copyright in the AI era. While the report establishes a framework for understanding the copyrightability of AI-generated works, it underscores that the debate over AI authorship is ongoing. As AI technology continues to evolve, courts and policymakers may face new challenges in determining the nature of authorship and ownership over AI-assisted creations. The key takeaway from the report is clear: while AI can serve as a powerful tool for creativity, human authorship remains essential for claiming copyright. This balance ensures that the constitutional goals of copyright law, promoting creativity and protecting the rights of creators, are upheld in this new digital landscape. Conclusion. The U.S. Copyright Office's report on AI and copyright marks a pivotal moment in the evolving relationship between technology and intellectual property law. By affirming the importance of human creativity in the copyright process, the Office has laid down a roadmap for future discussions and developments in the realm of AI-generated content. As the technology advances, the ongoing dialogue between creators, legal experts, and lawmakers will be crucial in navigating the complexities of copyright in an AI-driven world. The U.S. Copyright Office's recent decision regarding AI-generated content presents several counterintuitive insights regarding copyright eligibility and human involvement. Here are the key counterintuitive points. 1. Human creativity is central to copyright. The report emphasizes that human creativity remains essential for copyright protection. This seems counterintuitive in an age where AI tools are becoming increasingly sophisticated and capable of generating content independently. The notion that meaningful human input is required for copyright protection challenges the expectation that AI-generated works could easily qualify for copyright on their own. 2. Merely prompting AI is insufficient. One of the most surprising aspects of the report is the assertion that simply providing prompts to an AI does not constitute adequate authorship for copyright. This contradicts the assumption that engaging with AI, even at a basic level, could afford creators some measure of copyright protection. The implication is that significant creative effort must be evident in the final output rather than just the initial input. 3. AI as a creative tool, not an author. The report reinforces the idea that AI should be viewed as a tool for enhancing human creativity rather than a replacement for it. This is counterintuitive to the narrative that AI could autonomously create and own its works. The findings clarify that while AI can assist in the creative process, it cannot independently claim copyright, which raises questions about the future landscape of creative industries where AI plays a prominent role. 4. No need for legislative changes. Despite ongoing debates about the rights of AI-generated content, the U.S. Copyright Office concluded that existing laws are sufficient to address these issues. This may seem surprising given the rapid advancements in AI technology and the complexities they introduce into copyright law. Many stakeholders anticipated that new legislation would be necessary, but the office's stance indicates a belief that current frameworks can adapt to technological changes. 5. AI-generated content can be copyrighted. The report states that AI-generated outputs can indeed be eligible for copyright provided there is significant human contribution. This is counterintuitive because many creators and legal experts feared that AI advancements would lead to a dilution of copyright protections. Instead, the ruling establishes a new precedent that recognizes the potential for AI-assisted works to be copyrighted as long as they incorporate substantial human creativity. 6. Implications for future AI development. The forthcoming Part 3 of the report, which will address the legal implications of training AI models on copyrighted works, hints at potential liabilities for AI developers. This may appear counterintuitive given the current focus on copyright protections for AI outputs. It suggests that there could be a reckoning for how AI systems are trained, indicating that while outputs may be protected, the methods of training might be scrutinized for compliance with copyright laws. 7. Positive reception among creators. Many in the creative community have welcomed the decision, viewing it as a victory for AI artists. This reaction is counterintuitive in the context of the larger debate over AI's role in creativity, where there's a significant division between proponents and detractors of AI in the arts. The acknowledgement of copyright for AI-assisted works could signify a shift toward greater acceptance of AI as an integral part of the creative process, rather than a threat to traditional artistry. In summary, the U.S. Copyright Office's findings bring to light several counterintuitive elements in the discussion surrounding AI and copyright. The insistence on human involvement for copyright eligibility, the dismissal of mere prompts as insufficient for authorship, and the affirmation that AI must be seen as a tool rather than an author highlight the complex and evolving relationship between technology and intellectual property rights. The recent report from the U.S. Copyright Office, specifically Part 2 of its Copyright and Artificial Intelligence series, introduces several nuanced and potentially overlooked aspects that could significantly impact the future of copyright law and creative industries. Below are critical points from the report that deserve closer scrutiny, along with their implications. 1. Human creativity as the cornerstone of copyright. The report reaffirms that human creativity is essential for copyright eligibility. This emphasis on human involvement is crucial because it delineates the boundary between creativity and automation. While AI can generate outputs, the report specifies that human authorship must manifest through significant creative input. This is significant because it sets a precedent that could limit AI's ability to claim copyright protection for its outputs, reinforcing the traditional view that copyright serves to protect human intellectual efforts and creativity. 2. Defining sufficient human contribution. The report outlines 3 scenarios where AI-generated content can be copyrighted, which include the integration of human-authored content, significant modification of AI outputs, or the presence of creative expression from a human author. Many may overlook the specificity of what constitutes significant contributions. This requirement may lead to disputes over what qualifies as sufficient human authorship, potentially complicating the copyright registration process for AI-assisted works. This complexity could discourage creators from utilizing AI tools due to uncertainty regarding their copyright claims. 3. The role of prompts in AI generation. The report explicitly states that merely providing prompts to an AI does not constitute sufficient authorship for copyright. This distinction is critical because it challenges the notion that engaging with AI through simple commands or instructions can yield copyright-worthy content. Creators who rely heavily on AI prompts might find themselves in a precarious position, as their contributions may not be deemed expressive enough. This limitation emphasizes the need for deeper engagement and creative manipulation of AI outputs, potentially shifting how creators use these tools. 4. No immediate legislative changes necessary. The Copyright Office concluded that current copyright laws are adequate to address the implications of AI-generated content. This finding is significant as it suggests a reluctance to adapt the legal framework to the rapidly evolving technological landscape of AI. Stakeholders in the creative industries may find this position reassuring, but it could also mean that important issues related to AI, such as liability for copyright infringement when using training data, may remain unaddressed for an extended period. This could lead to increased legal uncertainty for creators and developers alike. 5. Future reports and legal implications. The anticipation of a forthcoming Part 3 of the report, which will discuss the legal ramifications of training AI models on copyrighted works, is noteworthy. This section is expected to delve into licensing and liability issues, which are of significant concern to AI developers and companies. Many AI models have been trained using vast amounts of copyrighted material without permission, leading to ongoing lawsuits. The outcomes of these discussions could reshape the landscape of AI development and its intersection with copyright law, possibly setting new standards for how AI can be trained and used. 6. Reactions from the creative community. The positive reception from AI creators such as Chris Kashtanova signals a shift in the perception of AI as a legitimate tool for creativity rather than a threat. The acknowledgement of their rights to copyright AI-assisted works can encourage more creators to explore and embrace AI technology. However, it also raises questions about the broader implications for traditional artists and creators who may feel overshadowed by the growing influence of AI in art and media production. 7. Concerns about future copyright ownership as AI technologies evolve. The potential for confusion regarding copyright ownership will likely increase. The distinction between human and AI-generated content may become blurred, leading to disputes over the ownership of works that incorporate both elements. This concern highlights the necessity for clearer guidelines and frameworks to navigate the complexities surrounding AI-generated content. In conclusion, while the report from the U.S. Copyright Office marks a significant step in recognizing the role of AI in creative processes, it also raises critical questions and challenges that stakeholders must address. The emphasis on human creativity, the definition of significant contributions, and the implications of future reports all point to an evolving landscape that requires careful consideration from creators, developers, and legal experts alike. Understanding these nuances will be essential for navigating the future of copyright in the age of artificial intelligence. 1. Human creativity is central to copyright. The U.S. Copyright Office's report emphasizes that human creativity remains the linchpin of copyright law. This assertion underscores that while generative AI can facilitate the creative process, it cannot independently claim copyright for its outputs. The report clarifies that copyright protection is contingent upon significant human involvement, signifying that mere prompts or instructions given to AI do not qualify as sufficient human authorship. This point is pivotal as it reaffirms the traditional principle of copyright law, which has historically protected human creativity, thus maintaining the integrity of copyright as a concept rooted in human expression. 2. 3 scenarios for copyright eligibility of AI outputs. The report outlines specific circumstances under which AI-generated content can be eligible for copyright protection. These include instances where a human incorporates their own authored content into the AI-generated output, significantly modifies or arranges the AI-generated material, or contributes creatively in an expressive manner. This framework provides clarity for creators about how to navigate copyright eligibility in the context of AI, ensuring that those who integrate AI into their creative processes can understand how to safeguard their rights effectively. 3. No need for legislative changes. Another significant takeaway from the report is the conclusion that existing copyright laws adequately address the challenges posed by the proliferation of AI-generated content. The U.S. Copyright Office has determined that current regulations are flexible enough to adapt to technological advancements without necessitating new legislation. This decision alleviates concerns within the creative community about potential legal uncertainties, allowing artists and creators to proceed with AI tools knowing that their works can be protected under existing legal frameworks. However, the office has committed to ongoing monitoring of technological developments and legal interpretations, indicating a willingness to adapt to future needs. For future legal implications concerning AI training on copyrighted works, the forthcoming Part 3 of the report is poised to tackle crucial legal questions surrounding the training of AI models on copyrighted material. This section will delve into licensing and liability issues especially pertinent for AI developers who have utilized vast datasets for training without explicit permission. The outcomes of these discussions could have far-reaching implications for the AI industry as it grapples with lawsuits and claims from human creators. Moreover, this focus on training practices signals a proactive approach by the Copyright Office to address emerging challenges in the intersection of AI and copyright, ensuring that the rights of original creators are upheld as technology evolves. 1. Burroughs Lithographic Company v. Cerrone 1884. This landmark U.S. Supreme Court case set a significant precedent regarding copyright and creativity. The case involved a photograph taken by photographer Napoleon Cerrone of the famous actor Oscar Wilde. The Burroughs Lithographic Company reproduced the photograph without permission. The Supreme Court upheld Cerrone's claim to copyright, emphasizing that photographs could be considered original works of authorship if they involved creative choices made by the photographer. This case established the principle that copyright protection extends to works that, while utilizing technology, still express the creativity and originality of a human author. 2. Feist Publications Incorporated v. Rural Telephone Service Company 1991. In this case, the U.S. Supreme Court addressed the issue of originality in copyright law. Feist Publications copied information from Rural Telephone's phone directory without permission, leading to a legal battle over copyright infringement. The court ruled that mere compilation of facts does not qualify for copyright protection unless there is a minimal level of creativity in the selection or arrangement of those facts. This case underscored the importance of human authorship and creative contribution in determining copyright eligibility, paralleling the recent considerations regarding AI-generated content requiring human involvement to qualify for copyright protection. 3. Bridgeport Music Incorporated v. Dimension Films 2005. This case involved a dispute over the use of a 3-second sample from a song by Bridgeport Music in a film produced by Dimension Films. The court ruled that the use of the sample was unauthorized and constituted copyright infringement. The decision emphasized the need for permission when using copyrighted material, and it highlighted the complexities surrounding the use of digital technology in creative works. The ruling has implications for how copyright law intersects with music sampling and digital media, similar to the contemporary challenges posed by AI-generated content and the requirements of human creativity for copyright eligibility. The recent report by the U.S. Copyright Office, which asserts that AI-generated content can be copyrighted if a significant human contribution is made, marks a pivotal moment in the intersection of copyright law and artificial intelligence. Looking ahead, several key trends and implications can be predicted as this framework evolves. 1. Increased collaboration between humans and AI. The affirmation that human creativity remains critical to copyright eligibility will likely encourage more collaborative efforts between creators and AI systems. Creatives may increasingly use AI as a tool for brainstorming, drafting, or refining their works, fostering innovative partnerships that blend human intuition with AI capabilities. 2. Expansion of AI-generated content. As creators gain clarity on copyright protections, the use of AI in generating content ranging from visual art to music and literature is expected to surge. The assurance that AI-assisted works can be copyrighted will empower artists, musicians, and writers to explore new creative avenues without fear of legal repercussions. 3. Legal framework developments. The upcoming Part 3 of the report addressing the legal implications of training AI on copyrighted works will be crucial. As AI companies face scrutiny over potential copyright violations from their training datasets, there may be a push for clearer licensing frameworks and regulations to govern how AI models are trained, which could lead to new legislative proposals in the future. 4. Evolution of copyright law. Although the current report suggests no immediate need for legislative changes, the rapid advancement of AI technologies may prompt ongoing discussions about copyright law. Future amendments may focus on defining the nuances of AI authorship and the extent of human involvement necessary for copyright claims. 5. Impact on traditional copyright holders. As AI-generated content becomes more prevalent, traditional copyright holders may face challenges in protecting their works. This could lead to increased litigation as artists and creators navigate the complexities of originality and infringement in a landscape where AI plays a significant role. 6. Rise of new creative professions. The integration of AI in creative processes may give rise to new professions such as AI content curators or AI-enhanced creative consultants. These roles could focus on optimizing human-AI collaboration, ensuring that the output meets both creative standards and copyright eligibility. 7. Global perspectives and regulations. As other countries observe the U.S.'s approach to AI and copyright, various international frameworks may emerge. This could lead to a fragmented global landscape where copyright laws differ significantly by region, necessitating a more nuanced understanding for creators working across borders. 8. Ethical and philosophical debates. The question of authorship and originality will remain a contentious topic. As AI continues to evolve, discussions around the ethical implications of AI-generated content, particularly regarding cultural appropriation and the role of human creators, will likely intensify. 9. Industry-specific adaptations. Different industries will adapt to the new copyright framework in varied ways. For example, the film and gaming industries may see a surge in AI-generated scripts and assets, while the music industry could explore AI-composed tracks. Each sector will likely develop its guidelines and best practices for utilizing AI while adhering to copyright laws. 10. Public engagement and advocacy. The positive reception of the report among creators suggests a growing community advocating for rights associated with AI-assisted creations. This advocacy may lead to increased public discourse and educational initiatives aimed at informing creators of their rights and responsibilities when using AI tools. Conclusion. The U.S. Copyright Office's report is a significant step in acknowledging the role of AI in creative processes while reaffirming the importance of human creativity. As the landscape of copyright law and AI continues to evolve, stakeholders across industries will need to stay informed and adapt to the changing legal and creative environment. ensuring that both innovation and artistic expression can thrive. The future will likely be characterized by greater integration of AI in creative endeavors, accompanied by ongoing discussions about the implications of this technology on copyright law and intellectual property.